carrying on our look at the sources of Scots law, and in this short film we're going to look at the more minor subsidiary sources of modern Scots law. We've already looked at the predominant sources in the modern era, being United Kingdom and European Union legislation and judicial precedent. The first source I want to talk about in this film is the source known as the institutional writers, or really the writings of those particular characters. These are the books of authority that from the 17th to the early 19th century tried to set out systematically what the law of Scotland actually was. The most famous of these was probably Viscount Stair, who through his institutions actually systematically gathered together and set out the civil law of Scotland for the benefit of future generations. And his writings are still taken as authoritative statements of the law, even by the appeal courts in 21st century Scotland. Other writers were such as Erskine and Hume writing a bit later, writing in the late 18th and early 19th century, set out a similarly systematic review and consolidation of what he took to be the laws of Scotland in the area of crime. Now, where their writings have not been codified through legislation, then they will stand on their own merits as sources of the law of Scotland. But it has to be particular works by particular writers. And it's not just any old textbook, for example, that would be able to be quoted in an appeal court case, let alone quoted with any approval from the bench. Nonetheless, they're an important source, although in the modern era, a minor source of Scots law. The next source I'd like to look at is the European Convention on Human Rights, and indeed human rights generally as a source of law. They have entered United Kingdom and therefore Scots law through a variety of mechanisms. The UK as a state signed up to the convention itself. Indeed, it was one of the founding authors of the Convention on Human Rights in the wake of the atrocities of the Second World War. And then the rights enshrined in the convention were brought into United Kingdom domestic law in the Human Rights Act 1998. At the same sort of time, the Scottish Parliament was being set up, and as a schedule to the Scotland Act 1998, the convention rights were listed, embedding them very firmly, therefore, in Scots law. And what that means is that as an individual, you can directly plead that your human rights as a protection that will be recognised by Scots courts and enforced by Scots courts where necessary. And some of the things we're talking about here are things like the right to a fair trial, to know the charges that have been laid against you, to have counsel represent your case, to test and lead evidence in your own defence, for example. And that all comes under Article 6. There's the right to association. Very important in a democracy that like-minded people can get together, whether it's to protest, to lobby, or simply because they want to get together because they share a particular common interest. And they should be able to do so without undue interference. You'll find that in Article 11. There is the right to private life, your family and your correspondence, that you should be able to shut your front door or metaphorically pull up your drawbridge and get on with your own private life if you're not causing harm to anybody, to do so without the interference of the state. And this includes the right to privacy of correspondence. The state should not be able to hack your emails, to look at your text messages, unless it has some sort of lawful grounds for doing so. And you'll find that in Article 8. And just in our selective review, there is the crucial right in a democracy of freedom of expression, that one should be able to speak one's mind, as long as one is not directly inciting criminal behaviour. One should be able to speak one's mind, even if that is a voice of dissent, a voice of criticism of the government. And in a democracy, a plurality of voices is very, very important. And it's not so much about whether we all agree. We should all be defending our right to express ourselves without, again, undue interference from the state. And so therefore, human rights are very much an identifiable, discrete source of Scots law. Next, we're looking at international law. International law is different from many laws because it really is laws that are concluded between states, between contracting sovereign states who agree, mostly by the instrument of treaties, about how they are going to behave towards one another and allow conduct between their subjects or citizens to be regulated one to another. One obvious example you might think of, for example, are the Geneva Conventions, which were agreements between states that said that even if we are in a state of war, there are certain threshold, fundamental, civilized ways of treating one another and their combatants in war that we will not cross, that we will not infringe. And this is about how to treat prisoners of war, how to treat the wounded, and so on. So that's a very obvious example. Less dramatically, international law governs a lot of trade and trade treaties about how we actually do business with one another. At the moment, America seems to be very much pursuing a protectionist policy, and the way out of trade protectionism generally is through bilateral or multilateral agreements between states, and these will take the form of international laws. With all of these, you will find that there are also international organisations, most obviously in this context the United Nations and the World Court and the International Human Rights Court, for example, and these bodies enforce international laws. There is even a treaty on the moon, where the contracting parties have agreed that the moon should be of common jurisdiction, that it is not up for grabs by one nation of the world or another. And actually the fate of this treaty points out and exemplifies one of the possible failings of international law, which is that the three countries that potentially could do something and have the technology about getting to the moon and colonising it haven't actually ratified the treaty. And that's because international law ultimately is an expression of a nation's political sovereignty. Nonetheless, whatever its practical weaknesses, it is a source of law. The UK is a signatory to many international treaties, and from the European Union beyond. Should Scotland ever become an independent nation, then it too would become a contracting party to these international law instruments. Finally, we're going to look at the very minor and almost entirely historical source of Scots law, which is custom. Now, custom really is of feudal or Roman origin, or perhaps Viking origin, in the example I'm going to give you in a moment. And it really represents a practice that has taken place in a jurisdiction which has been given the effect of law by the people who have carried on with it, that it is knowable and certain, that it's fair and reasonable, and that it's generally aligned with other laws of the land, even if it specifically constitutes an exception. Nonetheless, it is in broad alignment with the principles of the prevailing legal system. There isn't a lot of contemporary customary sources in Scots law today because legislation and precedent have very much overtaken much of the legal territory. The one example that you might want to give is that of what we call feudal tenure, and you will find that in the Orkney and Shetland Islands. It's a form of land tenure which owes its existence all the way back to the Vikings, to Norway. And these laws of ancient origins, which were never set down in legislation, but were nonetheless recognised as the way we did things in these parts, still have force today. They are recognised, it is recognised as a part of the law in these territories of Scotland, even being mentioned in other land legislation, for instance. But other than that, custom law really is a very minor and almost entirely historical source in 21st century Scotland.